Hi, everyone. This is Tom McMillan. Thanks for being with us today. This is our 46th COVID webinar. Today, it's going to be a very interesting subject. NIL, the ball is in your court. What are you going to do with it? Before getting into that, I just want to turn it over to Hannah to go over some brief housekeeping items. Hannah?
Good afternoon, everyone. For those who have yet to join us for a Lead One webinar, I want to welcome you first and foremost. Next, all attendees other than panelists will remain in a listen-only mode for the entire discussion. A couple quick housekeeping items. In case you would like to ask a question, there are a couple ways which you can do so. First would be to use the raise hand function. This is part of your toolbar, either on the right side of your screen or at the bottom. This will notify me to unmute you individually. You can also select the Q&A button as it appears on that same toolbar on the bottom of your screen. Clicking on this will open the submit a question prompt for the attendee to allow our panelists to answer. Finally, today's webinar is being recorded. All Lead One members will receive a copy of today's recording alongside a written recap via email within 24 hours of the webinar's conclusion. With that, I will kick it back to you, Tom.
Thanks, Hannah. We are going to try to do a number of webinars over the next few weeks to help our schools navigate this complex and uncharted new realities of name, image, and likeness. We all know the story that the institutions have been really thrown the ball here, and now they have to do something. And we have a very distinguished panel of guests to help us walk through that. Our moderator today is Oliver Luck, no stranger to college sports, former executive vice president of the NCAA and director of athletics, West Virginia University. Before I turn it over to Oliver, we're going to be looking at a lot of different areas of disclosure, conflicts with institutional agreements, as well as the use of institutional marks or facilities. There's a lot here to unpack. And with that, I just want to thank the panelists for being part of this, Maggie, Kendall, and Andrew. And without further ado, I'll turn it over to you, Oliver. Thanks.
Well, thank you, Tom. Hannah, thanks for all the prep work you've done. And good morning, good afternoon, depending on where you are in this great country of ours. I hope everybody had a great 4th of July weekend. Tom teed this up very well. This is Terra Incognita. This is brand new stuff. And I'm sure even over the holidays, you, like our panelists, like me, were sort of trying to follow what was happening in this nascent environment of name, image, and likeness. So let me quickly introduce our panelists. First of all, Andrew Donovan. Andrew was the head of regulatory affairs, including compliance at the University of Tennessee. He was also the former president of NAC, the National Association of Athletic Compliance folks, and is leaving Tennessee to become a VP of collegiate partnerships at Altius Sports Partners. So Andrew, welcome. We're delighted you're here. Maggie McKinley, a deputy AD and SWA at the University of Cincinnati. Thank you, Maggie, for joining us. And I believe we've got Kendall Spencer, who had a difficult time logging in, but I think we have Kendall Spencer as well. Kendall is a graduate of the University of New Mexico. He was a Lobo athlete, NCAA champ in the long jump, a very talented track and field star, also SAC chair, very engaged during his time as an undergraduate. And congratulations to Kendall on finishing Georgetown Law School this past spring. So we've got a freshly minted, once he passes the bar, lawyer. So we're delighted to have Kendall join us as well. So there's a lot to talk about, obviously, with name, image, and likeness. And I want to make sure that we can answer as many questions as you may have. So feel free to send those to Hannah, and then we can get those answered as well. So there are really 3 buckets of content that I'd like to talk about and have our panelists weigh in. The first bucket is a question that a lot of people are asking themselves at the university level, which is, what do I do with my institutional marks? What do I do with my intellectual property? Should student athletes be allowed to use my marks? If so, under what conditions? If the answer is no, a student can't use those marks, how will that be policed? That's the first bucket we'll discuss. The second bucket will be disclosure requirements for student athletes. A lot of the state bills, I think, as most folks know, have disclosure requirements. A lot of the universities will have disclosure requirements, but to whom, when should it be disclosed in the process? And if it's disclosed prior to the deal taking place, is there an approval right or a pre-approval right or disapproval right that the university may hold? The third bucket I'd like to talk about is this concept of category exclusivity. In other words, can the institution sort of block off categories where they have official sponsors so that student athletes would not be able to do NIL activity in those categories? And what sort of values should the universities be looking at as they consider blocking those categories off? So a lot to discuss. And before I jump in with our panelists, let me just sort of lay out very briefly the three scenarios that are in existence, I think, as everybody is aware. So if you're a school in a state that has passed an NIL bill, then obviously the advice is to follow state law. It's always good advice. Secondly, if you are in a state that has passed an NIL bill, but it's not going into effect until later this fall or perhaps in the next calendar year, you're in a position where you certainly want to set your own policies, but probably need to set those policies very consistent with the state laws that will be in effect in the not too distant future. And then there's a third category of schools that have a massive challenge ahead of them. Those are schools in states where there is no state law that touches on name, image, and likeness and what students can and cannot do. Those universities are obligated to develop their own policies and protocols. And those policies and protocols will be developed by the schools with very minimal NCAA guidance. The only guidance that the NCAA really is giving is that NIL should not be pay for play. It shouldn't be pay for performance. And secondly, that NIL shouldn't be used as a recruiting inducement. So those really are the only two sort of guidance points that the association is giving to those schools in states without state bills. So without further ado, let's kind of jump into some of the details on this. And as I had previewed, I'd like to talk about intellectual property, institutional marks, the famous Block M or the Flying WV or the Stanford tree, whatever logo you want to put in mind. These are literally world famous, very recognizable, obviously owned and controlled by the institutions. One of the questions that's come up is, should student athletes be allowed to use the university marks in their NIL activity? If so, under what conditions? And if the answer is no, those students should not be able to use those institutional marks. How in the world can an institution police that, given the fact that student athletes, as we all know, love to wear the gear, love to have video and all sorts of content on their social media platforms. So this is a fairly important issue. And let's start off, if we could, Maggie. I'll put you on the hot seat and ask, what do you and what does your university feel is the proper thing to do when it comes to institutional marks being used by your student athletes in NIL activity?
Yeah, thank you, Oliver. We've been discussing this for quite some time, knowing this was coming down the pipeline, and had a lot of conversations on our campus. And our campus already had a policy pertaining to the use of institutional marks. And so at the end of the day, as we were trying to figure out where we wanted to land on this, and with the executive order in Ohio, not saying really that it was precluded or not precluded, we basically landed on, well, we already have an institutional policy covering this for anyone who wants to use the institutional marks. Let's land there to begin. So we weren't going to create something that was more strict than what was already in place. Allow student athletes who wanted to use the marks to go through the normal process that's already established on our campus. So they would work with our licensing and trademarks department on gaining permission, or whatever company they might be working or representing now, having that entity go through our licensing and trademarks department to gain access to that. And then that decision would rest across campus and would be viewed through the same lens as anyone else. who would want to use those marks. So to start out, that's where we are. We're going broad. We're saying there's already something in place. If you want to do it, go that route. And so we've said, you're the experts in licensing and trademark. You handle this piece.
So I know we're early days in terms of NIL. Are you aware, and it's been a long holiday, of course, are you aware of any students who have applied for permission to use the Bearcat marks and the UC marks for their activity?
Not had a student athlete reach out to the department, but we have had an agency already reach out to the department asking what the process would be, how they could apply to use the marks. So we've already received that notification that someone has reached out, and we're anticipating there'll probably be some more. But we also know we're familiar with the process because our coaches have to do the same thing when they hold institutional camps and clinics. And so we know that some might elect just to not do that and kind of go in the generic red and black for anything that they might do.
Andrew, your former institution, University of Tennessee, are they in the similar camp as the U of C?
Very similar. We approached it from the same mindset. We thought it would be best to start from a broad place and narrow things in as time went along. Tennessee was a state with an effective bill on January 1st. And to a point Oliver made in the introduction, we felt it was best to align our process with that of the state bill so that we didn't have to put the toothpaste back in the tube, so to speak, or the opposite, open some things up that we had blocked. So we've done something very similar where we understand that any commercial entity can make a request to use our marks, or an individual for that matter. However, the one difference I would say is that we've attempted to streamline that directly through an entity within our athletics department. Concerns being that student athletes, obviously, as we know, expect an answer right here and right now. And so we wanted to give them a direct conduit within our department. We had somebody on our senior administration step up and take that responsibility on. To the question you asked, Maggie, about any requests that have come in, we did have a request from a student athlete on Thursday when the rules went into effect. And it was actually a really good learning opportunity, not just for us, but for the student athlete, because they had been approached about doing a trading card deal. And the company that had approached them for signing these cards wanted to put that individual on the trading cards with our marks. And so we were able to take that request from the student athlete and advise them that that company should be the one held responsible for the expense. So it was a good learning experience for our student athlete as well, so that we could educate them on the fact that in most cases, especially when you have a third-party commercial entity, this shouldn't be an expense you individually realize. So very similar approach to Cincinnati, simply trying to streamline that through the athletics department to start.
It's a great learning experience for the student athletes as well. So Maggie, are you concerned about a potential scenario where a student athlete did not request to use the marks, through the formal process, but nonetheless uses those marks? I guess the question is the institution prepared, to do what you would normally do with someone who's using the marks inappropriately and send a cease and desist letter?
Yeah, that was actually one of our great concerns because we know how harsh those cease and desist letters can come across. So we're working to try to soften that approach, an educational opportunity. And we've been hitting home throughout the month of June, tons of education to our student athletes, kind of what to expect, how to navigate these pieces. When you receive correspondence from these people, this is why they're reaching out. We've done the same thing here as Tennessee. We call it our NIL intake person. So we've designated a staff member who is all things, any NIL question, concern, anything is funneled to her. And then she's the expert on who it needs to go to. So they have this one central person to contact. So we don't have to worry about, oh, that's a compliance question. That's a marketing question. That's a licensing question. Just go to Alessandra. She's going to funnel it out. But yeah, we're working on that softer approach when they do misstep on
Right.
our intellectual property, whether it's filming in a certain space that they didn't have permission to film in, whether it's the use of our logos. Again, we're trying to drive home. We've tried to drive this home with our campus as well. We're an institution of higher education. It's about learning and teaching and maybe not going straight into that punishment or that threat of a lawsuit right away. So we're working on that piece. So
Right. So it sounds like you want to try to do that. You want to do that very collaboratively and in a
yes,
sort of educational context, right?
yes,
So
yes.
let me ask if I could, Kendall, have you been able to log in and join us?
Yeah, absolutely. I'm right here.
How you doing? Welcome.
Doing well.
So obviously you are aware of the topic. What's your sense of from a student athlete's perspective? You obviously were a great student athlete just a few years back. In terms of intellectual property, the institutional marks, do you think students should be able to use them? Is this going to be too cumbersome of a process to sort of go through the licensing trademark groups that typically handle those types of things on campus?
Yeah, so I mean, absolutely some very interesting questions, and the NIL space right now is ripe for these type of issues, right? So I love what I'm hearing so far when it comes to streamlining the process and trying to be as organized as possible. From the individuals that I've been able to speak to and sort of consult on some of these issues, that's really your one-stop shop to being as safe as possible, right? Being organized, because this is a big potential to get out of hand very quickly. I like the idea of student athletes being able to use a school's logo and their marks, provided that the school feels comfortable being able to manage it. Part of the problem with intellectual property is it only goes as far as you can protect it, right? So if you end up in a position where, let's say you give a student athlete permission to use your marks and the student athlete is involved in a deal that does not go well, they want to sue, but they also want to sue on the basis of how your marks were used. What happens then? And also an issue of who's getting the ability to use the marks versus other student athletes. So it goes into a process of how the decision is made. I like what Maggie and Andrew said too earlier about, hey, we sort of went to what we already had in place. I think that's a very, very intelligent place to start. But looking down the line in terms of what type of revenue sharing mechanism is there, how is it going to be handled in the future if those marks are used inappropriately, not necessarily by the student, but by the person that they're involved with. You're going to hear me today talk a lot about protecting yourself from future liability. That's my biggest focus, and really making sure that schools are not, incidentally putting themselves in a place where they're opening themselves up to future litigation. And in the intellectual property space, when it comes to NIL, as all of this happens under this larger realm of technology and emerging digital platforms, that can be incredibly difficult.
Yeah, no question. There's enormous, as Maggie had indicated, and Andrew as well, enormous educational responsibilities that need to happen in terms of student athletes. Let me, before we jump to the question of disclosure, we've got a bunch of questions coming in. Let me just read one that I find fairly interesting, and I'll open it up to each of the three panelists to opine on it. Question: there have been concerns expressed by this university's general counsel about restricting use of NIL associated with certain types of businesses. Does granting a student athlete a license to use marks who's engaged in that type of a business give the school more leverage in controlling permissible types of NIL activities?
That's so Oliver, that's exactly what I was talking about, right? You're going to have an internal process, as a lot of these institutions already have, with how their marks are used and who can use what. Now you're entering into a space where you're going to have a range of student athletes and different outside companies seeking to use these marks again. How are you deciding whether student athlete A is going to be able to use that mark versus student athlete B? And then you sort of exponentially make that a little bit more difficult by also saying, well, they're using it for this purpose, which we think is permissible, and this other student athlete is not, so we're going to give it to them. So this is where it gets really difficult.
Sure.
And
Well,
I don't know if it's
not to interrupt, but you're absolutely right. That's a big responsibility that the school would have. Clearly, the school carries a little bit more leverage because they can deny the student athlete the right to use the marks and logos. But there's also lots of other factors that come in, not the least of which is Title IX, of course. Andrew, Maggie, any thoughts before we jump to disclosure? I hate to move this along so quickly, but there are so many topics that I think we certainly need to touch on.
And this isn't anything revolutionary by any stretch, but I think Kendall makes a great point, and it goes to emphasizing consistency. And we're not going to be able to determine that, in my opinion, for quite some time, until we understand truly what activities our student athletes are engaging in, and where there are crossovers in those activities, and use of our facilities, use of institutional marks, things of that nature. So it's sort of a non-answer, but I think the reality is we're going to need to let this play out over some time to really understand what we're dealing with and how we respond to it.
Okay, let's jump ahead and talk about disclosure by the student athletes of their NIL activity, as well as of their relationship with the brand representative or marketing representative, agent, call that person what you will. Most of the state bills have a disclosure requirement for the student athlete. It sort of puts the responsibility on the institution to have some sort of mechanism for collecting that information. But here's a general question. I'm going to pose it to Kendall. Kendall, should a student athlete be obligated to report his deal or her deal? This is a fundamental economic right for a student athlete. What is the sort of compelling interest in the institution in knowing how much money perhaps a student athlete is generating, or what he or she is doing with his or her NIL?
This is probably one of the most difficult questions out there right now, right? And one of the reasons for that is because at what point is knowledge painful? At what point is knowledge putting, not painful in the sense of, oh, the student athlete is making more money than we are, but what I really mean is harmful. At what point does knowing the intricacies of a certain student athlete's deal now put you in harm's way, in the sense of, okay, well, you knew this was maybe a bad deal, or you knew there was some impropriety involved here. At what point does that open you up for liability for, maybe not protecting the student athlete against that because they're still a student athlete at your school? Now, that being said, I think given the stakes, I think it's absolutely appropriate to have some procedure in place where that partnership has to be disclosed. But the real question is, how much of that deal needs to be disclosed and how much information is really necessary? And I think that's probably going to be one of the more difficult questions. I think bare minimum is kind of a good place to start, until we see what these deals are looking like, and until it is established that the institutions and the student athletes have a little bit more protection. But I don't want to see schools demanding to see every single contract that a student athlete signs for the mere purpose that if the contract is bad and there's litigation in the future, the school might take some heat for that.
Maggie, what do you think the appropriate disclosure is, and when? Before the event, 14 days before the event, 10 days, 5 days after the event? What's your sense of what makes the most sense?
Right now, as we evaluated it, I couldn't agree more with what Kendall said. We were worried about the liability on the front end and creating what would be perceived as an approval process if they disclosed on the front end, and what our obligation would be to catch things that maybe later would lead to litigation because it was a quote unquote bad deal and we didn't advise them of that. So right now we're asking for those disclosures after the fact, and it's going to be more so who was the deal with, how much was the value, like what services or what was the exchange, because we still don't even know what fair market value is, so we don't even know what that is. So we're more trying just to collect to improve our knowledge base and gain an understanding of the value of some of these services that our student athletes might be entering into. So right now, we're just asking for a disclosure at some point after the fact, and we haven't even set a number of days yet, to be honest with you, because we're too concerned about creating a policy that our student athletes would violate because they missed it by a day or two. They didn't get the information that they needed in time. And so as we continue down this path, we'll probably narrow that and maybe set some more parameters just to help our student athletes so that they know kind of, oh, I need to make sure I get this in within 3 weeks after I signed the deal. But right now, again, we are starting with a back end process and kind of working and navigating as we move forward.
Do you, Maggie, envision any sort of negative consequence for a student athlete who would refuse or perhaps just forget to disclose deal points?
At this time, we're still, I go back to what I said earlier, we're trying to operate still in this education space. This is so new, the deregulation in this area is something that's so new for all of us. I go back to, been in this industry long enough where I remember where there was limitations on how much a student athlete could earn in employment, where it was nothing or it was $2,000. And when we deregulated that area, how much we moved in that space on campus and what information we were collecting. I'm viewing that a little bit like this, in that we need to educate, we need to inform. This isn't building in something that's a aha, I gotcha moment. No one's ever done this. They haven't done this. We haven't done this. Let's figure this out together, educate, and then maybe in a year, we've now come to the conclusion that it's beneficial for everyone to kind of put some more pieces into place that are defined.
Right. Andrew, any thoughts regarding disclosure? What do you think is sort of the best system for a university to put in place? And specific to that is, if there is disclosure required prior to the event, does the school, should the institution have the right to say, no, you're not doing this. This is a bad deal. It's not, it's not approved. Is that something that one can envision at the University of Tennessee?
Sure. I promise Maggie and I did not trade notes before this, nor did we work together in creating our policies, but we came from a very similar place as well. We didn't think it was appropriate at this time to go on the front end approval. And so very similarly, we've asked our student athletes to disclose their activities. They can do so beforehand. But what we've seen 100% of the time thus far is after the fact, and that is perfectly fine. I will note that one thing we've asked as a yes/no question amongst the other areas that we've asked to collect information on that Maggie mentioned is there a written agreement associated with this activity? Don't know exactly what Tennessee will do with that, if anything, after my departure. But the thought process there being, can we use this for education down the road to determine, are 20% of our student athletes getting agreements in writing, or is that number 80%? And what can we do to adjust how we educate our student athletes based on that? The other thing I want to mention, Oliver, and I promise I will get to the point of potential approvals, but the way we tried to communicate this to our student athletes was in a sense that this is a benefit to them as well, because it allows them to consolidate their information so that when it comes time for their parents or themselves to do taxes at the end of the year, they have a consolidated place where all of their NIL activities are kept together. And so there's a little bit of a carrot there for the student athlete and to assist them in being organized. And I was very pleased to get a call from a student athlete over the weekend to ask, where can I track this information? Rather than how do I tell you what I'm doing? So trying to change the narrative a bit so it's helpful to the student athlete. As it relates to front end disclosures, and I know some states require this some days in advance, I certainly think if that's the case, and you do have restrictions on prohibited categories or say conflicts with sponsors, I do think it's appropriate for an institution to be able to step forward and say that this is not a place in which the student athlete can engage. I think the institution needs to feel really strongly that they have a leg to stand on. I think they're going to want to have involved their Office of General Counsel to make sure that they don't have any legalities associated with them that are going to put them in hot water. But that's just not the approach we decided to take at Tennessee. And we had the good fortune of the state law eventually saying that also is institutional discretion.
Yeah. And Oliver, so I'll add to that point briefly. And I see some of the questions in the chat. Your best bet 99.9% of the time is to follow state law. All right. That's
Sure.
You're usually not going to go wrong with that. But you really want to try to manage liability and, approving, getting in the position to answer your question, Oliver, about do you want to be able to say no to certain deals? I think right now that's probably kind of dangerous. And it could be really difficult when it comes time to disclose the deal. And now it's like the school says, well, no, you can't sign this. Then you're getting yourself into really hot water. I think schools should be asking for minimum disclosure and just quite simply, who are you involved with? To me, it's unlikely that third-party companies and the individuals they're contracting with are going to allow for their contracts to be made public. But if you can get them, hey, that might be really helpful. At the end of the day, we want to educate student athletes and we want our schools to be in a good place.
So Maggie, you mentioned three magic words that are contained in a number of the state bills that have been passed, and I assume will be in at least a few of the university policies that are put into place, and that's fair market value. So the concept is that at the end of the day, right, you want to have these deals sort of reflect some sort of fair market value. Kendall, question, right? Freshly minted lawyer. Who's going to determine fair market value? Is there a mechanism for that? What does fair market value in a free enterprise system like we have in this country really mean? And who's collecting data from all these deals that are taking place and have been taking place since July 1 to even make a half-hearted attempt to determine what fair market value could be for an autograph session or social media endorsement?
Okay, so what is clear, obviously I get thrown that question because the answer is we don't know. We don't know. And a lot of the legislation was based off of this ambiguous notion of fair market value. The market's going to determine what fair market value is, right? But also part of that is going to be an incredibly subjective metric that's going to include a range of balancing factors that at the end of the day are going to be very specific to your geographical location, right? At the University of New Mexico, my fair market value in that market is going to be very different than what it looks like in California or in Texas. And that's for a wide range of different reasons, right? And so in terms of who's collecting that data and who is it that really determines what the fair market value is, that's the difficult part. That's what's really difficult. We don't know. In a perfect world, I think it'd be great to have a centralized location where all of that is tracked at a national scale. But I think what's probably going to end up happening is that's going to happen at a very state local level, because your fair market value is going to be attributable to the market. And it depends what your market is. My market in California, is it my market in certain industries? Is it my market with certain demographics? That's a person-to-person thing based off of what I bring to the table. And more importantly, it could change. It could fluctuate for a myriad of different reasons, whether it be time, injury, school, all that different stuff. So long-winded way, Oliver, of saying we don't know.
Well, that's probably the most honest answer that you'll hear during the course of this webinar. Let me ask a quick question. I find this to be short, to the point, almost a bit pithy, but it's a question that came in, and I'm going to give it to Andrew and to Maggie, because you all are experienced on campus with large athletic programs. Here's a question. If there are bad deals, open parentheses, excessive or bad actors, close parens, and the school finds out, what happens? Is it caveat emptor for the student athlete? Hey, he or she got himself into a bad deal. We all do that occasionally.
Yeah, I'm gonna tee it off, Maggie. So I think we have to be very careful, obviously, as institutional actors, which is a lot of what this discussion is surrounded in liability. In a lot of ways, it's no different than your elite student athlete insurance, and being careful as an institution that you're not making a recommendation to a student athlete one way or another on whether they should purchase insurance or have the institution purchase insurance for them. I think the same goes for this NIL space. Our messaging to our student athletes has been that you are now the CEO of your own business. And with that comes responsibility. You're going to have plenty of opportunities, and you're going to have plenty of responsibilities associated with those opportunities. And so I think if there is something noticed, we have to be very careful about the way we approach that with student athletes. I don't think it means we can't, in future educational sessions, be it one-on-one or in a group setting, use that as an example, not specifics, not giving out the privacy of the student athlete, but talking through case studies and talking through examples and giving student athletes and their families and the people associated with them ways to navigate potential issues and identify those issues through asking good questions, requesting certain information from the individuals with whom they get involved.
Yeah, and I would piggyback on that. It's trying to create a bucket list of questions that student athletes should be asking as they engage in this process, things to look at. We've done it before through the professional sports counseling panel. We've done this as they transition and graduate and go into the career field. where here are these questions you should be asking, here are the things you should be looking for, to make sure that it's in their best interest. There are always going to be things that are going to be missed, and we're going to kind of see a red flag, and it's probably how we approach that as an institutional actor. So it's more like, did you ask this question? Did you, you should maybe look at this a little bit more closely. Hey, did you hire someone that's advising you? And if you did, maybe you should go back and have a conversation with that person, and have them look into this piece a little bit more. So not necessarily telling them it's bad, not saying anything like that, but trying to get them to the right resources, to the right people, ask the right questions. We're just going to be in a really difficult spot. And I kind of say, like, here, my answer, this is my answer today. And then tomorrow we're going to run into something. I'm like, oh, okay, now we might have to change paths, but we just have to be, I can't believe I'm using this word, nimble. I think I used it about 100 times in council meetings the past 5 years, but we got to be nimble. We got to be able to switch it up. We got to be able to understand that we're going to continue to see things that we just weren't expecting or weren't ready for, and what's our bucket list of questions on how we're analyzing that.
Sure.
Our student athletes. The end of
It
the
all
day,
goes back to education. It sounds like. Let me keep moving forward, because questions are rolling in, and I also want to cover this issue of category exclusivity. I'm going to pose this question to you, Kendall. So obviously, athletic departments are businesses, folks, ADs. I was one. Need to go out and generate revenue and pay the bills. And part of that is, of course, corporate sponsorship. So, one of the pressure points, I'm sure, for the good people of IMG Learfield or JMI or any of the other multimedia rights folks, they're concerned about competition in some of those spaces. So, Kendall, University of New Mexico, you're a Lobo. The university has an official partnership with First Albuquerque National Bank. Should the university be able to say, nah, Kendall, sorry, you're a student. We forbid you, we prohibit you from doing an endorsement with Second National Bank of Albuquerque, because that's important to us, right? The revenue and the affiliation with First National Bank of Albuquerque, that's more important than your ability to do a social media endorsement for a competitor bank. What's your sense of where the fairness would be in that kind of a decision?
So Oliver, let me first say that as a University of New Mexico alum, my AD, Eddie Nunez, is in this, is one of the attendees. So I know he's listening to all of this. I'm probably going to get a text soon. So short and sweet here, I think, you as a university, you don't want to be in the position where you're moving like that, in the sense of saying like, hey, because this is a competitor, we don't want you signing. But the fundamental question here, because, well, I'll put it this way. The main reason there is just the issue of fairness, right? Again, you're as a university, you're putting yourself in a position of really becoming this approval mechanism for who can take what deal can you take. And even if it's not an issue now, in about a year or 2 years, once this framework gets a little bit more concrete, it'll probably be quite a big issue. What I will say is for all of us here, I would encourage universities to, first and foremost, decide what role they want to play in this. That's really the fundamental question. And maybe some universities do want to play that type of role where they're saying, hey, you can't take this deal, and here's why. What I do think is probably a safer, more in the middle type of approach, and I know that's why people hate attorneys, is I would say, go in there and again, educate the student athletes, say, hey, listen, here's what you might be doing. Here's the direction that we're going in. Is there a way we could partner? Is there some teamwork involved? Something along those lines where you're sort of killing two birds with one stone. You're providing the education without at the same time putting pressure on the student athlete to decline a deal, or just flat out saying, no, you can't partner with it. And then also it doesn't create a situation where universities are going out into their local communities and, quite frankly, creating a monopoly over all the big partnerships in the area and saying, well, you can't partner with anybody else because they would be competition. Does that make sense?
Well, I'll leave that to Eddie. He's going to have to decide if that makes sense. But well, you have a state bill, so you're elected representative.
Eddie can call me. I've got a great workshop for this. So
So let me ask you this question though. If a university says, hey, we have certain values and we don't believe that our student athletes at the University of New Mexico should be engaged in liquor endorsements, even if you're 21 or older, or sports wagering, right? Even if you're, of age to go into a sports book and place a, a wager on an NFL game or something. Are those restrictions, in your opinion, are those restrictions reasonable?
Yeah, absolutely, absolutely. Because at the end of the day, you're still trying to provide at least a base level amount of protection, not just for the student athlete, but for the university and for the university brand, right? So especially when we're thinking about, is this student athlete also using your marks, right? That's why sort of all these questions that we're asking are honestly sort of interdependent on each other, right? And it makes all of this very, very difficult. But when it comes to liquor and betting, things that could really negatively impact not just the fair market value of the student athlete, but the university and sort of the integrity of sport, I think that's absolutely an appropriate measurement to take. And maybe that's where the benchmark is set, right? What is something that could potentially negatively impact the sanctity of sport? Maybe we start there.
Andrew, you've been at the C level at Maggie U as well at your respective universities. Is there concern from multimedia right exploiters, and I say that in the commercial sense? Is there concern about their sort of positions being nibbled away because of the possibility of student athletes, and a lot of them, right, 400, 500, 600 on a particular campus, potentially doing deals with competitors? Have you heard that from any of those folks in that space?
I mean, we've been hearing that on our campus for over a year now, once this really started to pick up steam in the media. And so much like what we're talking about here with every topic, it's going to have to be worked through. And I think each individual institution is going to have to approach this a bit differently. Something that I would say that we all have to be readily aware of is the recruiting component of this. As much as we want to say that this doesn't get involved in recruiting, and that's been screamed from the mountaintops for over a year now, what are we seeing in the initial days of NIL? It's being used in recruiting. It's being publicized by institutions to talk about, look at the opportunities our student athletes have, which is indirectly associated with recruiting. And so I bring that up because I think we're going to find within our competitive environment, schools that do place heavy restrictions on certain categories, or more specifically, certain sponsors, are going to find themselves having to explain situations away when it comes to recruiting, because inevitably your rival will use that against you if they don't have the same types of restrictions. So I think the important part is understanding what your peers are doing, being able to articulate that on your own campus, and involving the right people on your own campus. That's inevitably going to be a compliance person that can help you understand how to navigate certain elements of that. But you also are going to need your marketing individuals, your media relations, your MMR folks, your general counsel. You need to bring all those people to the table so that all interests are represented and you can collectively come to a resolution on how you're going to handle this as an institution.
Maggie, does UC have a list of categories that have been discussed where your student athletes would not be able to do deals?
We have discussed it, but we have not landed on any restrictions at this point. We tackled this a little bit from the aspect of our executive order in the state of Ohio would allow us to put restrictions, but doesn't require us to, or doesn't actually prohibit those student athletes from entering into those. In one of our education sessions, we talked about guidelines from the Federal Trade Commission, and that essentially if you're endorsing a product, you need to disclose if you're using it or not. So if you are utilizing your sports wagering service, or your marijuana products or anything like that that aren't legal right now in the state of Ohio, that could put your eligibility in jeopardy, just because right now that would conflict with NCAA rules. When we get to this, I'll call it temporary legislation, interim legislation right now that we have, it took away a component that was in one of the proposals that had categories where student athletes could not enter into sponsorship deals with, because those activities were prohibited under NCAA rules. We don't have that right now. So right now we have not restricted things. I think I hate to keep bringing this up. I keep bringing up the education piece. We're trying to teach our student athletes how to brand themselves and what do they want to be associated with. Because whatever they're endorsing, whatever they're associated with becomes part of their brand. And so is that the avenue that they want to go down as they navigate the next stages of their career, whether it's professional sports, whether it's professional in the setting of a business, or whether it's, going to law school, and those things are not ever going to go away, right? They're there once they tweet them, retweet them, like them, put it out there on Instagram, do a cameo, whatever. That's associated with them for a long time. And so that's where we're trying to navigate, is not necessarily saying or restricting the categories, but more so saying, is that really a category that you want to be associated with your brand as you move forward in the space?
So again, right, it all comes down to educating the student athletes about what are the right short-term, midterm, and long-term decisions that they'll be making regarding their NIL, because your brand is you. It's what you have.
Yeah, and the other thing that we've talked about, sorry to cut you off, Oliver, is, when they look at those deals, what are they actually granting use of? Is it, making sure that's not in perpetuity, that in 20 years, their name, image, or likeness isn't still being used by that product down the road, so that they're really thinking about, is this a one-time use? Is this a year? Whatever that is, they're making sure that they're still retaining a lot of those rights to their name, image, likeness, and not selling themselves out for $5, $3, whatever it is that they're being offered.
Correct. So a question came in, and it's a very topical question. And I think many of the folks listening on to this webinar probably are familiar with it. I'll just read it. A business in South Florida will be providing $500 per month for each football student athlete on an athletic scholarship at the University of Miami. How are you handling contracts disclosures that promise payment for every student athlete on scholarship? And here's the key question. Is that essentially a recruiting inducement if it's guaranteed to every roster member? So is that a nice circuitous way to avoid using NIL as a recruiting inducement? So a business in South Florida giving each of the student athletes on the football team, each scholarship athlete, a certain sum of money. Kendall, what's your initial reaction to whether that would be considered a recruiting inducement?
I mean, listen, we can all keep it real here, right? This is the type of thing that we, more or less saw coming. Is it a recruiting inducement? Of course it is. Of course it is, right? Like, and you can essentially make that argument for a lot of different things, but something like this where it's like, hey, we're going to pay every person on the roster. All it takes is a tweet. All it takes is a text for that to get out. And, yeah, it's going to be an advantage. There's no, there's really no hiding behind that. It's just that type of interaction is a big part of what comes with, deciding that this is the direction people want to go. This is going to be a part of it now.
So you're in the camp that would be a recruiting inducement because you're keeping it real. And I appreciate that. Andrew, would you agree with Kendall?
Well, as a Miami grad, it's an interesting one. Go Canes. But that being said, I think Kendall is probably spot on that it looks and feels like a recruiting inducement. But what I really think it's going to come down to is, what are those student athletes being required to do? Is there a quid pro quo? And if they're doing something in exchange for that compensation, I think it can be argued that it's not a recruiting inducement, that it is a legitimate NIL deal. It doesn't look right. It doesn't feel right. But to go to your original question, Oliver, of what an institution can do when it comes to disclosure, I would use as an example of how Tennessee's approached those deals that our local media is obviously very interested in this. They're reporting on everything they see in social media from our student athletes. So we have a running list right now of what our student athletes have engaged in based on those media reports and what we've seen on social media. And it, surprise, surprise, does not directly align with what's been disclosed. So we are using that as a tool to follow up individually with those student athletes to remind them of the disclosure process. And I think, to your question, Oliver, that is something that could be done in that situation so that an institution can follow up individually with student athletes, or in this case, with a group.
And I guess the question really is if it's a group license, right? If every scholarship football player agrees, to the terms and conditions of whatever that offer is from the South Florida businessman, if it's a group license, a group license sort of in and of itself isn't a recruiting advantage. Some schools may have them, some schools won't. And theoretically, if you have a group license and you're in the football team or the women's basketball team or the softball team, then you're going to participate at some level, right? Depending on the value of that group license. Maggie, going back to Kendall's point, would you agree that that would be a recruiting inducement, something that would attract, high school football players to a school like the University of Miami if they knew that there was a deal in place for every one of their scholarship athletes?
I would say yes, I would agree. And it's all how the deal is set up, unfortunately. In the state of Ohio, I believe our executive order precludes it being attached to your attendance at a specific institution to try to eliminate that recruiting inducement piece. So not being familiar with the state of Florida's law that's on the books, I think there's always workarounds, right? I think Andrew and I made our career finding ways to make things happen within the rules. And so I think at the end of the day, that you're going to see more and more things like that. You're going to see people who are affiliated with a specific institution or have an affinity with a specific institution try to set up ways to help that institution in new ways in this space. How long it's going to last, I have no idea. It's an insane amount of money when I do the math in my head on 500 times 85 times the number of months. But I do think that those are going to be the things that are going to raise the red flags initially and are going to draw the attention of people. And there's going to have to be some work done to make sure it's not the quid pro quo per se, and that there is an exchange of services, even if it's a autograph in exchange for $500. And is that going back fair market value? We don't know. That could be worth $500 to an individual to get an autograph once a month from a player. I just don't know. Is it worth 20,000? Is it, what is that as we move forward in this space? I think there's so many questions. And I think that's the one thing as a takeaway from this webinar is these conversations are going to continue every single day as we move forward. There's so many unknowns and just kind of working through this new space and trying to get some solid footing as we move, and we're helping our student athletes navigate something that was never available to them previously.
So let me ask a question. This is not one that came over, but it was raised over the holiday weekend by a friend of mine. And I'm going to, again, pose it to Kendall. So Kendall, you were a star athlete. Let's imagine you participated as the point guard for the Lobo basketball team, very successful program playing in the pit, right? And you said to your athletic director, you said to Eddie, hey, I'm not going to do any media for the university. I'm only going to speak publicly to radio station KABC because they're paying me for a 30-minute show every Thursday and Monday evening. And I'm not going to speak to the local Albuquerque newspaper. I'm going to only speak to a website that is paying me for my views and my thoughts on the season and the game and the coach and this. And by the way, I'm not going to do any TV interviews either, only with the local, ABC affiliate that's paying me as well. Is there anything that would prevent that student from sort of taking that kind of a position, maximizing, again, in this case, maximizing his earning power while he's a student athlete? Kendall, what do you think?
Not really, right? If just like putting myself in those exact shoes, if I were to go to Eddie and just tell him, like, hey, these individuals wanted to interview me and I don't want to, I don't want to take the interview, I could just not take the interview. And my institution, I don't think any institution, not just on the moral side but on the legal side would be able to compel me to speak to certain entities, right? And so the fact that I've now made the reason for not doing so because this other company's paying me, I mean, it's unfortunate, it's a character issue, it's a moral issue, but in terms of, is there a mechanism in place to force someone's hand for who they can, or better yet, for who they must speak to? No, absolutely not. And I would be interested to see one. Now, I think it's different when you start talking about people's marks and, you know, using what may have been posted on social media and that type of thing. But I don't think I've ever seen or heard of any type of mechanism that would compel any student athlete to speak to any of these commercial news outlets, honestly, for any reason. And I think that is something that is usually in our handbook that we get as student athletes when we first do our shout out to the compliance people, when we do our compliance intake week-long type of thing where they're telling us about concussions and all the things you can and cannot do. Great place to put the NIL stuff, by the way. But yeah, so I don't think that would be I don't think that would be able to be forced. I think it would be unfortunate, and I think that's a way that student athletes would be able to maximize their earning power.
Maggie, you've got a super talented quarterback, Desmond Ridder, at the University of Cincinnati. I'm sure the administration wouldn't like it if he took that kind of a position, but would you agree with Kendall that there's nothing preventing a student athlete from doing that?
Yeah, absolutely. I think that, our student athletes aren't employees. They are not classified as employees. There's nothing that they sign that requires them to make appearances or things like that on their own time. So I would say that if Des decided that he didn't want to do post-game interviews or he didn't want to do promotional spots, we would say, okay, great, thank you. And now we'll have someone else do it. I mean, the question actually used that as an example. He came in to record a couple spots for us earlier this summer. And then he said, well, when name, image, likeness goes into effect, can I charge you for this? And we said, no, you can't. The way we understand what our law might be, no, we can't actually, but you can elect not to do it and go somewhat, do this for someone else who will pay you. And he's like, okay, well, no problem. I was just asking type deal.
Asking for a friend, right?
Asking for a friend. But the question did come up. And we haven't had anyone yet say, well, I don't want to show up for this or I want to show up for that. Because as part of our educational process, the past 12 months, as we talked about, we're going to be one of those free advertisers for you to get your brand out there. We're going to tag you in social media posts so people know how to follow you. We're going to put out images. We're going to put out things to help build your brand for you so then you can have a better opportunity to capitalize on that when this space opens up. So that's the way that we've educated them on it. So to allow us to help them kind of build their platform, build their followers. So when this opened up, we had one student athlete who went from, I think, maybe 2,000 followers to 15,000 over that course of that time. So to us in Cincinnati, that's a lot because we're a smaller market in terms of our competitive space. So they understood it, they got it so far, but we anticipate there will be someone who gets a deal from their Barstool Sports student athlete, and all and their media opportunities are limited to only Barstool Sports. We don't know because we haven't seen what that application process and what that agreement is. So we anticipate there could be student athletes who are now precluded from participating in media opportunities with our local media because they signed something that gives them exclusive interview rights through an entity.
Yeah.
So fun times ahead.
Yes. So we're getting close to the top of the hour. We'll probably go over, for a couple of minutes. That's okay. But I did want to ask each of the panelists a question that came in, and it's not, it's sort of a general question about the new environment and the new relationship that student athletes will have with their institutions. And this individual writes, student athletes wanted to have autonomy to do all these types of things, and that's true. They're going to have to learn from their mistakes. Are institutions ready to give, I guess, a lot of sort of leeway to student athletes to make mistakes, whether that's signing with the wrong agent or committing, to an NIL deal that doesn't work out for whatever reason, or the length is too long and it's too restrictive? Are departments prepared to let kids make mistakes, because I think inevitably with this kind of a marketplace, brand new, just rolling out, mistakes will be made. Some unintentional, some probably sadly intentional. And I think we'll begin to see some of the stories of student athletes suffering because of those. Andrew, you've been with the institution, the University of Tennessee, for a long time. Is that something that you think schools are prepared for?
If they're not, they better be. That it's just the new reality of what we're facing right now. And if you haven't been doing education with your student athletes and all the other involved stakeholders on your campus, there's no time to waste. You need to do that right now. I think what's going to be most important is that as institutions, as representatives of institutions, we are collecting the information that is coming into us, and we are utilizing that in a way to educate student athletes so that the same mistakes are not repeated. I think that is the best thing we can do. Shameless plug here in my new role with Altius, but that's exactly what we are going to do with our institutions, to try to educate student athletes and the people that are dealing with them on the daily basis in this space on how to prepare them to maximize their opportunities, to do it in a responsible and an effective way, and to truly understand you are the CEO of your own business. You're going to have plenty of opportunities, and with that is going to come immense responsibility. We have to be prepared for student athletes to make mistakes, and we have to be there to help them pick them up off the mat and make sure that they don't put themselves in that same position going forward.
Fair enough. So last question, Andrew, I'll let you ask Kendall a question that I think has come up in your mind. So go
Kendall,
ahead and put Kendall on the hot seat.
Absolutely. Kendall, I greatly appreciate your perspective on this. And I'm very curious to go back to the space of prohibited categories. And this is something that's been on my mind for a few months here, particularly with state laws. Tennessee is one of them that precludes areas like alcohol, gambling, adult entertainment. I'm curious for your perspective as a former student athlete, high-level student athlete at that, what your thoughts are on an institution that may engage in a sponsorship in, say, the gambling or the alcohol category that contemporaneously holds their student athletes from doing so?
So I think my initial question, or I guess my initial thought would be, I would want to know what that relationship looks like, right? I think we do need to juxtapose sort of the difference between saying like, hey, we don't want you involved with this company at all, versus we don't want you doing these type of things with these certain companies, right? I think that's something that all of the universities, all of these entities involved in this space now need to be asking, because I think it is going to be not just company and third party and person specific, but I think it's going to be activity specific, right? So, is it the case that, this liquor company is sending money to the university or is sponsoring, a basketball game activity, but the way that they position their, their logos, is that going to be different than if the student athlete says, hey, I want to go shoot a commercial for, whatever, company you guys also engage with that you don't want them to deal with, right? So I think for me, the question would really turn on what's the relationship look like, and really what is it that they're going to be doing? Because again, it really comes down to this element of fairness. Overall, though, in the best interest for student athletes, I don't want this new NIL space to look like the music industry, right? Where you have people sign these premature deals before they've gotten a chance to be represented, before they've gotten a chance to be educated on what might be good, what might not be. And then years down the line, they blow up or they've achieved a great amount of success, not realizing that they've signed over their IP for the next 20 years. We should be learning from what happens in the music industry, which is, again, what my workshop teaches, but more importantly is something that I think institutions need to be a little bit more understanding of. And again, it's not a bad thing. It's really from an awareness perspective. And they need to understand that everybody's trying to learn as they go right now, not just the student athletes, but the ADs, the administrators, and the universities as a whole. So it's important to sort of keep that balancing act as a resounding theme, and to understand that in our generation, all of this happens in this technological world, right? In the world of social media platforms that are not regulated. Schools cannot forget about that, because that is going to throw a huge wrench in all of this.
Yeah, that's an excellent point. Thank you, Kendall. So we're about 5 minutes over. I'll ask if there are any final thoughts, very brief, before we turn it back over to Tom. Maggie, thanks, number one, for joining. Any final thoughts?
No, I think the biggest thing here is because each state is operating a little bit differently than other states. It's going to be a challenge, and I think that especially for conferences, I think this is a unique thing where you have conferences that have institutions on so many different regulations and coming to a space of being comfortable, being uncomfortable because you're operating differently. But I think that the communication, the transparency, the collaboration is going to be critical as we move forward in this space. So that it's not a recruiting advantage, but it's an advantage for our institutions and our student athletes to operate as consistently as possible moving forward.
Yeah, well said. Andrew, thank you again for participating. Final thoughts.
Thanks for having me. Final thoughts would be understand what your peers are doing. Have a good idea because this is 100% going to come into the recruiting space. And I think in that same vein, just as important, perhaps not quite as important, but close to as the student athlete education, I think is education to the coaches. The coaches need to understand not just what the baseline rules are, but they also need to have a really good understanding of the state law or your institutional policy to keep you out of hot water when it does come time for recruiting. So recruiting, understand that is going to be a key component of this, and education of your coach is almost as important as the student athlete.
Awesome. Thank you. And Kendall?
Yeah, so again, thanks for having me here. It's been great to be able to dialogue with all of you guys. I'll give you guys a couple free tips for whoever's still listening. First and foremost, get everything that you guys are doing for your student athletes, all the webinars, all the classes, get that in writing and like have that documented somewhere for a lot of different reasons. Two, have a good relationship with the individuals advocating for you at the state level. Have a good pulse of what might be changing on the legal side and on the regulatory side. All that stuff is incredibly important. And lastly, communicate with your student athletes. Student athletes are going to be taking a much larger leadership role here. And I think that's a good thing, but using that as an opportunity to educate and understanding that technology is going to make it a little bit more difficult, but give yourselves time to adjust and understand that it's not about getting it done. It's about getting it right.
Words of wisdom. Thank you very much, Kendall. Appreciate it. Tom, I'm turning it back to you.
Tom has actually asked me to close us out this afternoon. I appreciate y'all for joining us again. To those who have hung on this long, again, we appreciate your attendance. Like I mentioned at the top, we will circulate this recording alongside a written recap within the next 24 hours, but I will leave you with the rest of your afternoon. Thank you again to our panelists, and we will see you again next time. Thank you all.
Thank you, Hannah.
Thank you, guys.